Good afternoon, everybody, and a very warm welcome to our expert panelists for today's session and the various participants who have taken time out from their busy schedule to attend this first webinar session on conducting board and general meeting in the realm of SS-1 and SS-2. It's my pleasure to share that more such webinars are planned to be organized by ICSI on Secretarial standards, everybody, and a very guidance note covering the topics of professional interest. You will all recall that we had one program, Secretarial Standard Week, sometime in April 2022, and that received a humongous response from the members. And there was, in fact, there was a demand that we should have one more program. At least every year we should have a Secretarial Standard Week, but we should have one more program to refresh the memory of the members itself. Today, our focus would be on mandatory Secretarial Standard, that is SS-1 and SS-2, which is recognized under the Companies Act 2013, and the guidance note issued by ICSI thereon. Friend, let me share with you that in the past, we have received overwhelming response from professionals for the first ever Secretarial Standard Weeks organized by ICSI in the month of April 22. And based on the roaring feedback received, it was decided to organize more such webinars on Secretarial Standard for the benefits of the members. Unfortunately, in the last program, which was held in April, we could not have the presence of Madam Sharda, who was unfortunately unwell and she could not join us. But there she is with us today, and I'm sure all of us will be benefited by her presence over here. I'm sure that our members will continue to provide their support for these initiatives of ICSI. The Secretarial Standards always evolved around principles of good corporate governance, and today we have with us two eminent panel experts to unleash their principles of best practices enshrined in the Secretarial Standards on the board and general meetings. As a moderator of the session, I once again welcome you all to this webinar. And before we proceed, let me also take the pleasure of introducing the panelists for you. The program will be like this. After my introduction, we'll have each of the panelists to give their presentation, maybe spread over 35 minutes to 40 minutes. And thereafter, we will have a set of questions to be asked to the panelists. And in case any of the members, participating members, want to share any questions, they can do so in the chat box, which will be shared with me by HO. Ma'am Sharda is a seasoned company secretary serving several clients as their conscience keeper in corporate governance matters. As exclusive alumni of IIM Bangalore, she is certified as a distinguished Toastmaster by the Toastmasters International USA. She served the Bangalore chapter of ICSI as its first women chairperson and is currently a member of the expert group on Secretarial Standard. She is a trustee on the board of Matru Foundation, set up by the Padma Shri and Parliamentarian Dr. Malati Hola for specially abled children. I should also tell you, she was the comparer for the National Convention, which was held in Bangalore, and she did a commendable job over there, winning the appreciation of all the members present. She wears many hats as a mother, career woman, professional speaker, startup mentor, jury member, and most importantly, and one should not forget this, she is a cancer champion. She is a survivor of cancer, and she is she's so beautifully placed in terms of answering any questions on that topic as well. We will leave it for some other occasion. Welcome to this program, ma'am. Then we have our own Kalidas Ramaswamy. He is academic, he is a fellow member of the Institute, MBA in Finance from Jadavpur University, Kolkata, BCom Honours from St. Xavier's College, Kolkata. Professional experience, more than 4 decades of experience in industry after starting professional career in the year 1978. That's the year, incidentally, I passed out my CS. Worked in leading companies such as Ambuja Cements, Reliance Power, ACC Limited. After superannuation from ACC, he is now in practice as a partner of a leading firm of practicing company secretary. Why should he hide the name? BNP Associate, where I am also the party. Academic and professional achievements. He was a visiting faculty in XLRI Jamshedpur and authored more than 100 articles on issues relating to corporate law, semi-regulation, corporate governance, etc. His articles have been published in reputed journals such as Chartered Secretary, Journal of ICSI, etc., as well as on various web portals. In fact, he's a regular speaker in seminars, conferences organized across the country by professional bodies, and he is the kingpin for our firm, who advises all of us on various matters relating to corporate law. Presently, he is member of the expert group on Secretarial Standard and earlier served as member of the Secretarial Standard Board as well. The author of following books is a specialist editor of A. Ramaya on Company Law 19 edition. Several other publications on corporate laws has been to his credit. We welcome you, Kalidas sir. Now I open up the door for Madam Sharda to give her presentation. Before we have the presentation from Mr. Kalidas, before I can take questions and answers. We have generally programmed it for 2 hours. Maybe it will take 10-15 minutes more. We will do it. Okay, over to you, ma'am. Thank you.
Thank you, Mr. Narasimhan. Namaste to all. I would like to thank at the outset ICSI, the Central Council members, and also our expert group on Secretarial Standards members for reposing the trust in me and giving me an opportunity to speak once again on Secretarial Standards 1. And BN sir, thank you very much for your personal touch in the introduction, for that warm personal touch. I will share my screen with my presentation. I hope it is visible.
Yes, it is visible.
Yes, thank you. Before we start off, I definitely want to highlight this. I have done that in the past also, that all of us as members of this institute must be proud of this product, if I may call so, Secretarial Standards, which is made in India. It is a Shuddha Deshi product that is made. And in fact, many other countries have adopted some standards from ours. And it is not the efforts of this expert group or the previous one or the previous one. I'm sure several groups, several committees in the past have worked towards evolving the secretarial standards and bringing it to this stage where in the 2013 Act, it has found place as part of the legal provisions. So we must be really proud of that. And I do recall one of our past presidents, Dr. P.V.S. Jaganmohan Rao, he was mentioning that somewhere, I think it was in his term in 2000 or 2001 and the early 2000s, that secretarial standards were unveiled in Bangalore. I vaguely remember him having said that. So over a period of last 22 years, you can see how it has evolved and it has found the prime place of distinction. A disclaimer that this is not any legal advice, it's only my views. Is it a coincidence that exactly a week later, many of us may be meeting in person or virtually at the 50th National Convention of ICSI. And the theme there is Company Secretary as a governance professional, as a Vishwaguru. So you are going beyond. So we are going beyond being a leader. We are calling ourselves Vishwaguru. So you can imagine the kind of responsibility that we carry as an institute and also as individually in our roles as leaders in our organizations or in the society. So I thought it fit to capture this, that the quality of a leader is reflected in the standards they set for themselves. So you can choose what standards you want from here, but ICSI has rightly, in the pursuit of professional excellence, has set certain standards, starting with SS-1. One sec, sorry for this. I'm not able to view my. Yeah, so this is a quick bird's eye view on the various sections and the rules which are relevant, which have been touched upon in the Secretarial Standards 1. So I don't have to explain more, the slide says it all, including the rules. Now, there is Secretarial Standard, there is also Guidance Note. Both of them are important. While Secretarial Standard forms part of Section 118, Guidance Note, as the name goes, is giving us guidance on how to follow the standards. So secretarial standards is basically a codified set of good governance practices. What is the purpose? It is to integrate, harmonize, and standardize the diverse secretarial practices followed by companies. And I must say, in my own practice, I have seen over the years, there were so many variations today, more or less, most of us try and follow the secretarial standards, even though they are not mandatory. In fact, some of the companies, small companies, they're not mandatory, but still people follow that. Now, guidance note. What does it do? It explains the procedural and practical aspects, and it contains illustrations, it contains charts, it contains specimen resolutions, annexures, all kinds of tools and things which are useful for us, and it appropriately integrates the replies to various queries also raised. So you can find queries and replies. You'll also find some explanation by way of illustration. I would say when I started reading it, each time I read, I find that there is something new in which. So if you raise a question, if you go back to the guidance note and read, I bet that you will always find an answer in that. It's almost like Bhagavad Gita, where, you know, for every question in our life, we will be finding an answer. Guidance note is something like that, but it is not a static document. That much I can tell you. It is constantly undergoing revisions. The last one for SS-1 was as of 31st December 2020. And after that, there are one or two few changes, that's all. But this is something which is an ongoing process, as standards should be. So these are the 9 standards: convening a meeting, frequency, quorum, attendance, chairman, passing of circular resolution, minutes, how do we preserve the minutes and other records, and also the disclosures. So SS-1 is encapsulated in these 9 standards and the guidance notes which are made on that. So today in my presentation, I will be presenting to you my views and also the highlights of these standards. Let us look at applicability. Now, Secretarial Standard 1 was made effective from 1st July 2015. It was revised as of 1st October 2017, and there were 2 guidance notes. The last one, as I told you, the latest one is revised as of 31st December 2020. Now, coming to applicability. It's applicable to all companies, private and public. On the right-hand side, there are also certain exceptions. We'll go to that. So one is meetings of the board. The other is board committees. These are the 4 committees, statutory committees, which are recognized under the Companies Act: Audit Committee, NRC, CSR, and Stakeholder Committees. It's applicable to all of them if it is applicable to the company. If there are any other committees, then it is optional unless in the articles itself, the company chooses to make it applicable. What about non-applicability? It's not applicable to one-person company if there is only one director on the board. Section 8 companies, again, it's not applicable, but the rider is that in 2017, as per the MCA notification, if the Section 8 is compliant in filing its annual report and its annual return. So that rider is there for many of the exemptions in the Act, which also includes for SS-1. Of course, it is not applicable to both private and public international finance companies via this notification 2017. So we know very clearly almost all the companies are covered except one person and Section 8 company with certain riders. And it's also applicable to committees. So whatever we are going to discuss in the next 30 to 35 minutes, we can keep this in mind, and many of the questions will get answered following that. Okay, I am moving to the first one. Convening a meeting is the first standard. Now, who has the authority to convene a meeting? It's very, very important because the validity of the meeting itself will be in question if a person who does not have the authority, he or she convenes the meeting. Now, what does this standard read? It says any director may, including an independent director and a company secretary or any person authorized by the board, on the requisition of a director, shall convene a meeting of the board. Now, if you split it up, a director, including an independent director, he can be executive, non-executive, independent director. He shall convene a meeting of the board, but it normally the request goes to the company secretary or the person authorized by the board in the absence of a company secretary. And the other 2 people, company secretary or the authorized person, cannot convene on their own. It shall be only on the requisition of a director, and he cannot do it. Even if the requisition comes, it always has to be in consultation with the chairman, failing him the managing director, failing him the full-time director, unless a different type of authority is given in the articles. So this is very important to understand who is authorized to give the notice, which is the first document, to call for the meeting, you give a notice, and who is authorized to do that. I picked up a few important points from the guidance note. Guidance note is very extensive on notice, on adjournment, quorum, and minutes. Now, some of the best practices are, as a best practice, a director who is requisitioning a board meeting should send his request in writing along with the proposed agenda. That is something logical that we expect. If you want somebody to convene a meeting, you must tell the company secretary, why do you want a meeting? What are the agenda points you want to include in that? And he must give it in writing. Now, any person authorized by the board, whether he's an officer or non-officer, it has to be clearly identified. So it can't be any person. It can't be even a decision of the chairman. So at the board meeting, it has to be identified if there is no company secretary or in his absence, who else will be authorized to carry out the responsibility of convening a meeting. Now, when we say non-officer, in my understanding, it can also be an external consultant. It can be a PCS who is giving external service, or it can be within the organization who may not be an officer. So clear identification of the person so that when the directors receive the notice, they know it is coming from an authorized source and they know that it is a genuinely called meeting. Now, CS or authorized person must get approval of the chairman, managing director, whole-time director to convene the meeting. We've already seen that unless otherwise provided in the articles. What happens? The articles can also provide stricter norms that it has to be only the chairman or any other kind of, it may also be getting the consent of anybody else. Perhaps it's a joint venture company, then a joint venture nominee who is there on the board, he also must consent. Some such thing, which are stricter than what the Act and the standards provide, that can be provided. What happens if there is an oral request from the director? Now, sometimes they may just give an oral request and say, go ahead. So as a company secretary, you need to handle this with a lot of maturity, with diligence and care. So the company secretary or authorized person, what is given in the guidance notice, he can put it in writing to the chairman, MD, WTD, with a copy to the director saying so-and-so person has requisitioned a meeting. So it's also there in writing and we are confirming that this is our correct understanding. If the chairman doesn't approve the request, because it says in consultation, so the chairman may not approve the request for convening a meeting, what happens? The company secretary needs to check the AOA. If the AOA is silent on this, it's very clear that the company secretary does not have unbridled original authority. He cannot convene a meeting. So the director, in the absence of a company secretary being able to convene a meeting, then the director may go ahead and convene a meeting, and the other provisions which are applicable for a director calling for a meeting will become applicable here. Now, it's very interesting to see that sometimes you inform the directors, you advise the chairman that there are some statutory requirements for which you need to conduct a meeting, or the time gap is getting laxed and you need to conduct a meeting. But if the board does not take the next step to convene a meeting, even then the company secretary on his own cannot convene a meeting. So we are secretaries to the board, and on our own, we cannot convene. At best, you can advise, you can take all steps and inform and educate the directors. So these are some of the points which are very relevant under the heading authority for convening a meeting. Next, let us move to important points. These are simple, logical ones, but very important. What is the date? What is the time, place, and what is the mode of conducting the meeting? Because today with virtual meetings, this becomes very relevant, unlike in the past where it used to be only in-person meeting. Now, if you look at date and time, meeting can be convened at any time on any day, especially the original meeting can be convened on any day, even if it's a national holiday, though good governance practice suggests that we must not do it on a national holiday, except if it's a national holiday for adjourned meeting for want of quorum. If it is for want of quorum, the adjourned meeting can be held, but the guidance note again suggests that don't do it on a national holiday, do it at least the next day, which is a working day. Obviously, because the secretariat is available, there are people who may be other than the directors whose services may be required, presence may be required to attend the meeting. Now, when can it be held? Preferably in working hours. And you may also have to keep in mind to check the AOA if specific time is mentioned in the AOA. Now, working hours is a big question when we are having directors from across the borders. So it is important for the company secretary to check the convenience and availability of all the directors and come to some convenient time. For example, we had a meeting of one of the companies where I'm advising, and the director was sitting in the US. Very elderly gentleman, 90 years old, but he was willing to come for the meeting virtually. For him, it was 6:30. Trust me, but he came for the meeting at 6:30. For us, it was somewhere 8:30 or 11 or some such thing, depending on the time zone. So it's important to make sure that it should be in convening, preferably during working hours. So I would see working hours as working hours for the company. Now, place, it can be convened at any place. Normally, it is the registered office. It can also be at the corporate office or any other place which is convenient to all the directors. Mode, as I told you, virtual meeting or other, which is to be held through video conferencing or other audiovisual meetings are allowed today. This is nothing new. And the pandemic has only increased the need for holding such meetings. The requirement is recording of proceedings of such meetings are deemed to be made at the venue indicated in the notice. So sometimes there is a question saying if it is an electronically held meeting, why should we have a venue? We should mention the venue in the notice because by a deeming provision that will be treated to be the venue in the notice itself. And that's where the recording is supposed to be held. And that's where the security and integrity of the meeting also has to be ensured by the chairman and the company secretary. Now, according to the standards, there is a requirement to start numbering the meetings. So every meeting to be serially numbered, there is a flexibility, do it on a calendar year basis, do it on a financial year basis, or you can also do continuous meeting numbering. It can start if it is people, companies which were already existing prior to this standards coming into place. The suggestion given is you can start after 1/7/2015. And the numbering system is to be recorded both in the notice as well as in the minutes. Now, what happens if a meeting gets adjourned? The serial number of the original meeting and the adjourned meeting should be same. For example, if it is meeting number 3 of 2022, and if it gets adjourned, it should continue as meeting number 3, but we could add saying that adjourned meeting. What about participation through electronic mode? Few important points for us to note. Participation of a director through teleconferencing. So it's very important when we say VC or OAVM, it is audio visual, other audio visual means or video conferencing. So only mere teleconferencing will not constitute a quorum. I know my worthy panelist, Kalidas sir, has some thoughts on these. That's why I want to perhaps kind of give a disclaimer that mine will be a plain vanilla presentation. You can expect some fireworks. You can expect some exotic flavors from Kalidas sir, who will have some thoughts on SS-1 also, in addition to presenting SS-2. Now, the director has to inform the chairman or the company secretary about his intention to participate through electronic mode. However, nothing stops him if he wants to participate in person also, it's possible. Some of these provisions kind of have become redundant because earlier we had to give this intimation. Today, it has become by default that most of the meetings are being held through electronic, but he has a right to also be present in person. So it is important to find out if arrangements have to be made for him to be present in person or he will be attending it electronically. Now, original and adjourned board meeting can both be held through electronic mode. So there is no restriction. Today, what does the law say? Where does it stand? All types of agendas in a board meeting can be considered through electronic mode. But just take note of this. If you look at the guidance note, of course, it is updated up to 2020, but these 4 or 5 restricted matters earlier could not have been held through VC or OAVM. In the wake of pandemic, it was relaxed by MCA. However, this rule has been completely, Rule 4 has been completely omitted. Why? The notification dated 15/6/2021. So today, any kind of agenda can be transacted through a meeting which is held through virtual mode. So I finished authority, I finished the date, time, and place, and I've also finished the electronic mode in brief. Now let's move to notice. This is the fundamental document which convenes the meeting. Now, when we say notice, is it just a notice which has the date, time, place, and mode? No. When you say notice for the meeting, it should be read along with a detailed agenda for the meeting. It's not just the list of agenda matters. It is also notes of the agenda and all the supporting documents. How should it be sent to the directors? Either it can be sent by hand, by post. When we say post, it is registered post or speed post. And just to draw your attention, the courier is not permitted in the section itself. So the standard has maintained the same emphasis. It can also be sent by email. Normally, we prefer to send it as an attachment If it's a short meeting, it can also be text of the email. Now, if it is a meeting with number of agenda items and many documents, then it can also be given as a URL link. Notice and agenda must be sent to both the alternate directors and the original director. Though he may not be present, he has a right to receive the notice and it has to be sent at the same time. Now, what happens if the board has already decided that every first Friday of the quarter we are going to meet? Or if it says, predetermined dates are there or predetermined intervals are there, either in the articles or in some agreement or in the previous meeting. Even then, the standard says that we must give a meeting notice. Especially today, we are all burdened with so many notices that, our calendars are full. It is just impossible to remember, even if it was predetermined and minuted. It is good practice to give notice of the meeting, even if the date was known earlier. What is the duration of notice? It says 7 days, leaving the date of the meeting, unless the AOA provides for a longer time. So AOA can provide, say, 10 days, but it cannot say 3 days. It can only be stricter, except, for some matters where, some UPSI matters are being considered, then it makes sense that with the consent of the majority of the directors, where at least one ID is present, this can be done at a shorter notice. Because equity listed companies, if you look at the guidance note, it clearly says for different agenda items, there are different duration of notices which can be given, which are required to be given. Now, where should the notice be delivered? What is the address? Obviously, if it's a hard copy, there is a postal address to which it should be delivered, or it can be delivered to the email address registered with the company of the director. If that is not there, then let's just rely on the email address which is given at the time of obtaining the DIN. In addition to all of this or any of this, it can also be specifically requested by the director. For example, he can say, also give it to one of my secretaries, or give it to me. It should come by post to my corporate office or to some other email ID, which is not any of this. So please make note of all of this and make sure that it actually reaches the director. 3 important points under notice. Let's look at supplementary notes. After you have issued the notice and the agenda, if you want to give additional information on that item as supplementary notes, can it be done? Yes, it can be circulated. Even at the meeting, it can be placed, or it can also be given prior to the meeting, which will obviously not comply with the 7 days. That's why it's called supplementary notes, but it can be given. What is the requirement? While the notice can be circulated, the agenda can be taken up only with the permission of the chair and the majority directors, including the independent director. At least one independent director, if he is there, they should be present at the meeting required for taking up the agenda. So majority directors present at the meeting, they should agree along with the chairman. Only then it can be taken up. Chairman does not have unilateral authority to just allow any supplementary notes to be presented, because these are important matters and decision making gets influenced. What about shorter notice? Now, decisions taken at meetings with shorter notice. What does it mean? Less than the 7 days, must have presence of at least one independent director. So make sure if there are independent directors in such a meeting, the decision is taken with a shorter notice, at least his presence is there and he has not objected to it. If the independent director is not there, what happens? It will become final. That means the decisions there will become final only after it is ratified by at least, again, one independent director. If there is no independent director, it should be ratified by the majority directors of the company. And how to ratify, that is also explained in the guidance note. What about additional agenda? After circulating the agenda, you want to introduce something at the meeting. General meeting, it's not possible, but for board meeting, committee meetings, it's possible. How is it to be done? It can be considered at the meeting only with the permission of the chair, again, plus majority directors present at the meeting. So it is very important that the majority directors present in the meeting must consent to that. What happens to the decision? Again, the decision can become final only if it is ratified by the majority directors of the company. There it was majority directors at the meeting. Here, finalization happens only if it is approved, ratified by the majority directors of the company, unless they themselves were already present at the meeting. So these 3 points to be kept in mind. Now, why it is important is proper meeting notices must be sent to all the directors following all the process that we have seen till now. Otherwise, the resolutions passed with irregular notice. The notice can become technically irregular and they can be challenged. They are not valid. So it is the responsibility of the company secretary and to advise the chairman properly and make sure that these notices are sent properly along with the agenda. They move to frequency of meetings, both board meetings and committee meetings. All of us are aware that there should be at least 4 board meetings in a calendar year with not more than 120 days gap. Now, even if one of the meetings gets adjourned, still the 120 days gap must be honored. So it is very important how you calculate. You can't take shelter that the meeting got adjourned and I could not, it has got the 120 days gap has got breached. Now, there is some relaxation for one-person companies, small companies, dormant companies, and startups. Startups are again coming under private limited companies, but DPIIT has recognized startups, and they have certain relaxations. They have certain exemptions in the Act. Now, they should hold at least one board meeting in one half of the calendar year. That is from Jan to June and July to December, and the gap should be not less than 90 days gap. Now, startups were included in 2017. Coming to Section 8 companies, it just says one board meeting in each half of the calendar year. But in my experience, I have seen it's very rare to find the companies having just 2 board meetings. Even Section 8 companies today, the kind of activities that they are undertaking, they are huge and they have such, societal significance that they are all meeting more often and they are deciding. So this is the bare minimum that they need to maintain. Committee meetings can be held as and when required or frequency as stipulated by the board. Of course, SEBI LODR has some requirement for more meetings, 4 meetings for an audit committee. What is important is the board which constitutes the committee should also decide how often they should meet. If they don't decide, then the committees themselves must decide. Independent directors are again required to have their own meetings. They need to hold at least 1 meeting in a calendar year to review the performance of the other directors. Now, here it's important to note that CS shall facilitate convening and holding of such meeting if required, because a lot of leeway is given to the way these meetings can be held. Guidance note also has just given some guidance and not made anything mandatory. It's interesting to read those provisions. Moving on to quorum. This is the basic minimum, but what's required, it's not enough if you just start off the meeting with a quorum. It also has to be there throughout the meeting. And if any person is leaving the meeting in between, that also has to be properly captured, which means even if the person moves out or if he is interested in anything, we must ensure that the decision taken are with proper quorum. Now, for calculating the total strength for quorum, what needs to be done? The vacant position in the total strength of the board, interested directors, they should not be counted. Now, AOA can provide for higher quorum or presence of a nominee or an invested director. So you must keep in mind for joint venture companies, normally it says at least 1 each from both the parties must be present or a certain higher quorum will be. So we must be conscious of what is the specific requirement of the company we are handling, or you are there as an employee company secretary. Interested director is not to be counted for quorum. Just look at the exception which was there. MCA notification in 2015 and 2017, it says interested director of private companies can participate, vote, and be counted for quorum after disclosure of interest, but not the chairman. So there is a very clear table given out in the guidance note which talks about interested directors and the way they are to be looked at, and also both in public and private companies for both interested directors as well as RTPs. Directors who are present through virtual meetings, obviously they can be counted for quorum. It does not disqualify them from being recognized for quorum. What happens to alternate director? If he is to be treated as interested, he will not be entitled to vote if he himself is interested. However, if the original director is interested and AD is not interested, then he can be counted for quorum, because remember, both of them get the meeting notice. But I think in the wake of pandemic and these virtual meetings, the concept of alternate directors and the requirement to have an alternate directors is slowly coming down, I guess, because people can join meetings from anywhere in the world. A few more points. Disclosure of interest. How is it to be given? All of us are aware it has to be through the MVP one at the first board meeting in which he participates when he is appointed, or at the first board meeting of the financial year every year. And whenever there is a change, the onus is on the director to give this disclosure. Now, interested director, if he is disclosing his concern at the board meeting where the contract or arrangement is discussed, if he does not, he has to do it. If there is a breach, what happens to the contract? It becomes voidable at the option of the company. But then there is also a consequence on the director. He is liable to vacate his office. What happens if all the directors are interested? The matter should be referred to the general body meeting. What happens if there is a related party transaction? The interested director can neither be present nor at the meeting nor vote. Now, quorum requirements for companies. We saw what is it for board, what is it for committees. It is again as specified under the Act, or the AOA can specify any specific quorum or any other law if this is, some of the committees are constituted under any other law. If not, all the members are to be present. So the constituting authority board, it will do well if the act is of any of the specific acts are silent, then it is better for the board to also say what is the frequency and what is the quorum. Moving to adjournment. If the meeting cannot happen because the quorum is not present, the meeting gets shifted to the same day, time and place next week. What happens if again there is lack of quorum? In the adjourned meeting also, the meeting gets cancelled. Earlier, this was not clear. In this act, it is very clear, and the standard is re-emphasizing that it gets cancelled. Now, this is for lack of quorum. There could also be a situation where the chairman is also authorized to, entitled to adjourn a meeting for any reason at any stage. It can be, there is some calamity, there is some force majeure, or if he feels that this meeting should be concluded or it should not be concluded, it should be adjourned because more time is required, more information is required, he can adjourn it. But he should make sure that the majority directors who are present at the meeting should not disagree. That means they must consent, only then he can adjourn. Moving to attendance, a lot of procedural issues here. Quickly, we have captured what are the key highlights. Pages in the attendance register which are maintained, they have to be serially numbered with the date. They have to be preserved for at least 8 financial years. Who needs to sign? Every director, company secretary. The invitee also needs to sign a register, or it can also be in a loose leaf format and has to be bound at regular intervals. Now, chairman is to confirm virtual video conferencing attendance. If somebody is attending through video conference, what do? We have attendance sheet and we mention that attended by VC, and then it is authenticated by the chairman. Roll call obviously will be taken. Company secretary or chairman should authenticate and sign each page of the attendance register. Where is it to be maintained? It is to be maintained at the registered office and open for inspection by all directors. Also, a few more people, that is the PCS, Secretarial Auditor, Internal Auditor, Statutory Auditor, any officers of the ROC or any other government, if authorized by the Act. So it can be kept open for inspection. It should be in the custody of the company secretary or any other authorized person. There should be a proper locking system. Now, we also are aware that every director cannot attend every meeting. So there are cases where they may seek leave of absence. So it should be granted only when it is sought specifically. It has to be appropriately minuted. If a director does not attend a meeting without seeking leave of absence for a period of 12 months, then he gets disqualified and then he vacates his office as director. For the purpose of vacation, how should it be counted? After the last meeting is attended, from the next meeting which he has not attended, that's the meeting. From there, you look at the 12-month period. Now, board should take note of this vacation in the next meeting. And as good governance, the intimation should also be given to the director that he has vacated the office. We are moving to SS-5, that is chairman, a very important role, especially in relation to convening, conducting the meeting and making sure that the sanctity and integrity of the meetings are kept in place. Now, chairman of the company shall be chairman of the board. If there is a chairman of the company, he shall be the chairman of the board. Else, the directors shall elect the chairman. Sometimes we also find in articles and through JV agreements or other agreements that from each party, one of the person is mentioned as a chairman for a specific period or on the happening of certain events or if some triggers happen. So there are different ways in which a person can chair the meeting because of these different provisions. Otherwise, it is From every meeting to meeting, the chairman could also change. What happens if the chairman himself is interested in any item of business? He shall hand over the meeting to any other disinterested director who is present there, and he shall resume as chairman. Today, we are seeing that most of the chairmen who are well-versed with these provisions, they themselves recuse themselves from chairing the meeting and then rejoin when this item of the agenda is discussed and done with. Now, it's a very important duty and responsibility of the chairman to safeguard the integrity of the VC meetings especially and ensure compliance of a lot of procedures. There are procedures prescribed. Look at the provisions, look at also the guidance note. Like I told you, articles can provide for the tenure of the chairman. Now, he shall have a second or casting vote unless it is provided otherwise in the articles. What happens if a person is the chairman? Can he also hold the role of managing director or CEO, or the other way around? That means he's holding dual positions. Is it allowed? It says section 203 says cannot be appointed as chairman unless articles provides otherwise, or unless the company does not have multiple businesses. If it has multiple businesses, there is an exemption. This is the exemption which the section provides. Public companies with paid up capital of 100 crore plus annual turnover of 1,000 crores with multiple businesses and CEOs for each such business, they are allowed to have. Of course, equity listed companies also, there are restrictions, especially from April 1st, 2022. This dual position cannot be held. In case of related party transaction, again, an interested chairman cannot even be present at the meeting. What about committee meetings and chairman? The board should appoint a chairman for the committee, else the committee can elect one among themselves. Nobody is present within 5 minutes. One of the members will be chosen as the chairman. I finished chairman, finished quorum and adjournment. I am moving to circular resolutions. Circular resolutions, all of us, I know we use it so very often. There are detailed guidance note suggestions which are given and guidance which is given. Circular resolutions are deemed to be passed at a duly convened meeting and they have equal authority. That is why there are some protocols and frameworks which are to be followed. Now, all items of business may be considered for passing except certain items, but there's a big list. I would request all of you to refer the guidance note, which is quite in detail. Who has the authority to propose a CR? It is again the chairman, managing director, or any non-interested director. Obviously, the company secretary cannot circulate any resolution on his own. It is to be approved by the majority of the directors entitled to vote. So leave out the disinterested directors. Few more provisions which are interesting here. We should make sure that it's not just the majority. No, at least 1/3 of the directors, if they say that they need, this cannot be passed at a CR and they want a meeting, then a meeting has to be called for. Now, normally a 7-day time window is given for either giving their assent or dissent on the circular resolution. If no response is received by the director, it is deemed that he has abstained from voting. Now, deemed as passed on the last date of assent by the directors. Now, this is very important. When does the last director give his assent, or the date on which the assent from more than 2/3 should have been received? Because then you know that the 1/3, which is their balance, which becomes less than 1/3, they cannot ask for a physical meeting. So it is not just the majority. Remember who are the disinterested directors, and also keep in mind that more than 2/3 should have approved this circular resolution, and the date on which the last of the 2/3 of the directors approve, this is deemed to be approved. CR is, all of us are aware, to be noted in the next meeting. How is it to be circulated? It's like any other agenda with all necessary papers. In fact, here it should be which the text and the commentary should be speaking for itself, because you don't have a meeting set up where people can ask questions unless they come back to the chairman or the company secretary and ask for additional information. It should be self-explanatory with all the documents which are required to help the directors take a decision. It can be delivered either by hand, speed post, registered post. Here, courier is mentioned, email, or other recognized electronic means. If there is an alternate director, the draft should be sent to the original director also for information. Proof of sending and delivery of circular resolution also should be maintained. Just because you have had circular resolution does not mean that you can dispense with the requirement of holding a board meeting. That is different. Resolutions passed by circulation shall be noted at a subsequent meeting, and if there is a dissent or if there is any comments or anything, that also can be placed as part of the next board meeting minutes. Coming to minutes. Minutes, of course, I think it's the longest section, the biggest section in the guidance note, and rightly so, because it's so very important minutes which are recording the decisions taken, the process of taking the decision. So there is no restriction in law. Some of the interesting things is it can also be in any other vernacular language other than English. It is still valid. Well-drafted minutes, all of us are aware, it is not just passing a resolution. It should have a preamble. It should have a summary of the discussions. How did the discussion, it need not be verbatim, but the rationale, the dissent, especially from the independent directors, their comments, all of that has to be properly recorded. And if there is anything under any other item, like I mentioned earlier, it has to be ratified by the majority of the directors. Now, normally, what is a good practice to have all the notings in the initial part of the meeting for record, whatever you want to inform that in the meeting, then you come to discussions, you come to approvals, you come to action taken. But in any order that you, along with the, in consultation with the chairman, you can come up with that. Now, all appointments should be specifically minuted. And the decisions for some things, it has to be in the form of a resolution wherever it is statutorily required. In other cases, it can be in the narrative form. What about signing? The minutes should be signed by the chairman of this meeting or the chairman of the next meeting. Every page has to be initialed. You should not have any page in between which does not have any text, or it should be scored out. All these things are very much already prevalent, and many of us are already aware of this. Now, scanned signature, DocuSign signature, all these are not permitted. It should be only digital signature. And if you are using digital signature, in my opinion, you can't use it on a printed sheet of paper. It has to be only if the minutes itself is maintained in an electronic form. Inspection, there's an interesting question. Can a director inspect the minutes of the meeting held before his directorship? After he becomes a director, yes, because he may want to know what decisions were taken in the past and he may want to keep himself abreast of that. So he can ask for the previous minutes. And even after he ceases to be a director, he can also ask for at least the last meeting where he attended. Make sure that there's a formal procedure for him to request for that, and maybe a NDA also can be asked. Now, this is an important point. As a practicing company secretary, secretarial auditor, statutory auditor, all of us ask for a copy of the minutes. The guidance note states they can inspect the minutes. So if the company wants to part with the copy of the minutes, fine. Otherwise, you can inspect the minutes and take relevant extracts for your audit. A member obviously is not entitled to inspect the minutes of the board unless he has this authority or the power is given in the AOA. Sometimes in joint venture companies, they say that maybe a finance head or somebody else other than the director himself can also ask for certain documents. So if it is there and included in the AOA, be mindful of that. It is sacrosanct that in 30 days time period, everything has to be completed. There is no more excuses for any delay. For example, from the time the meeting has been completed, within 15 days, the draft has to be circulated to all the directors. In practice, what we do is we give a first draft to the chairman, make sure that his concerns, his points are all well recorded. Then within 15 days, it is going to all the directors. From there, they have another 7 days time in which they can communicate their comments. After that, within the next 8 days, that means in a total time period of 30 days, the minutes must be finalized and entry in the book has to be made. That's why if you see, you say signing of the minutes is different, date, entry in the minutes book is different. Now, signed minutes again has to be circulated to all the directors, whether they have attended or not. I think this is prescribed in all good intention, and I would really advocate this because it makes sure that there is no room for confusion, no room for any dispute that something was not included or something was not discussed, but it has been placed. Everybody knows what's happened. So either you circulate the signed minutes, otherwise place it in the next minutes, next meeting. I'm coming to Secretarial Standards 8. We have dealt with a lot of documents, notice, minutes, register, attendance register, agenda documents, circular resolutions, all of them, they have to be preserved by the company. Now, minutes book obviously should be in the custody of the company secretary, if not one of the directors who is authorized to keep custody. It should be there permanently in physical or electronic form. Electronic form, the timestamp is defined in the secretarial standards. It has to be in a secure computer system. Notice, agenda with notes and all documents, as long as they are relevant, they have to be maintained, or 8 years, whichever is later, may be destroyed with the approval of the board. Minutes, we know it's a permanent document, and in case of any merger or amalgamation, the transferor company shall keep the minutes of the transferee company also. Sorry, it's the other way around. Now, all other documents other than this minutes notice, they may be destroyed after 8 years with the approval of the board and central government in case of amalgamation. This is with relation to preservation of records. But mind you, if there is any dispute, it is better for the company, even if a lower period is mentioned, to keep those records, not only till the litigation is, in the first stage is cleared, but also till the appeal is exhausted. Coming to the last secretarial standard, which is on disclosure. It is the responsibility of the board to disclose in the board's report. The report of the board shall include a statement of compliance, because it's a collective responsibility under 134(5)(f) that they must give out a responsibility statement saying all the applicable laws are complied with, and there is a system to ensure that the compliances are possible. Now, secretarial standard after the revision has suggested that this sentence should be there in the board's report. All of us are doing it. The directors have devised proper systems. Devising the proper systems is important to ensure compliance with the provisions of all applicable secretarial standards, and that such systems are adequate and operating effectively. It's a important and a very, such a critical responsibility. That's why the whole process and the standards, they gain so much of significance. What was there earlier in the guidance note and secretarial standard? It said annual return and annual report had to disclose all this: number of meetings held, dates on which the meetings were held, dates on which committee meetings, how many meetings they attended. So voluntarily, if you want, we can do all this. Some of it is already, the numbers are already coming up in the annual return. But today, this, the left side, what I have shown you as suggested statement is a must. What is the penalty for non-compliance? Because this is mandatory. Penalty is prescribed under section 118(11). If any default is made in complying with the provisions, on the company, there is a fixed sum of 25,000 per offence, and on the officer in default, INR 5,000. We have just picked up from I asked one of my team members to pick up this. So he went through a certain orders. It's not, we are nowadays looking at it that the regulator is also looking at all this very seriously, and they are enforcing the provisions. Not that the earlier law didn't have, but the regulator, the government has given teeth to it, and the regulators are looking at it very seriously. And it can be quite damaging to the pocket, both for the company and for the officer in default. Look at this: non-maintenance of minutes for 4 years. This was a default. Non-maintenance of distinct minutes separately for board meeting, committee meeting, and general meeting also, it was penalized. Now, approving financials through CR in violation of this one, and SS-1 was also referred to in the order. Failure to disclose compliance with SS in the board's report, which I talked of in the previous slide. All these were penalized by ROC Bangalore. So there could be other ROCs who are doing it. So it is important that all of us take this seriously. Now, Delhi ROC failing to serially number attendance register. It may look a very minuscule and unimportant thing, but even that has been picked up. Not conducting 4 board meetings in a calendar year, obviously it's a serious offense. So these are the kind of penalties in the last 1 or 2 years that have already been levied. I just want to close my presentation with a reference to secretarial standards in orders. When I say these are not judicial orders, but quasi-judicial orders, in one case, I would like to mention that one of our senior members, Advocate GP Madan, he had posted in one of the groups that he also, I think, happens to be a past member of the Secretarial Standard Board and must have contributed to these secretarial standards. In one disciplinary proceedings by IBBI against a resolution professional who had failed to send notice of the committee meetings, COC meetings, to the members of the suspended board. So during the course of this hearing and also in the written submission, Advocate GP Madan had placed emphasis on SS-1 with respect to interested director and related party director, and why the RP chose not to send the notice, and also referred to the minutes, that the minutes was circulated. Now this is found place in the order, and it has been, the case was disposed of with a mild caution to the concerned RP. So I'm just trying to highlight how our own members are also advocating it by placing it in their written submissions in their hearings, and the regulators as well as the judiciary is taking note of this. I would also like to mention one more order which was passed by NCLAT Chennai. Our own company secretary is a young company secretary from PCS from Chennai, K. Gaurakumar. In an O&M case, he had argued in the course of the hearing and also in the written submission that a circular resolution was not circulated to the first appellant in that case. So merely that it was not circulated to him, he was left out as required under 175, and the reference was also made to Secretarial Standard 6.2. After consideration of the submissions, the tribunal stayed the implementation of the CR till the next date of hearing. Perhaps he can give an update of what happened there. But what is important for us to know is how to make use. It's not only just implementing it, but also making sure that how this is also advocated, and non-compliance can also be used to our advantage. This is something that I wanted to highlight. So with this, I have taken, I think, about 10 minutes longer than what is set out for me, DN sir. Sorry. But definitely we make no apologies for setting high standards. It is not only for my firm, but I'm speaking, if I'm allowed to speak on behalf of the expert group and ICSI to the community and to the corporate India as a whole, that we make no apologies for setting high standards. And I'm sure we will continue to evolve these standards and continue to set high standards. Thank you very much. And I would now give the screen back.
Thanks a lot. Thanks a lot, Sharda. That's a pretty exhaustive and a very comprehensive one. I'm also glad, extremely glad, that you brought upon some of the orders of NCLT, how these have been highlighted in their orders. And of course, the penalties which are being imposed by the ROC, I think the credit has to also to go to your ROC in Bangalore, who has been in the limelight for several reasons, giving orders of, huge penalty being imposed, but some of them have been revised as well. Thanks a lot. Now I'll request Mr. Kalidas, my friend and mentor for our firm, to take it forward as far as SS-2 is concerned. Over to you, Mr. Kalidas.
Thank you. Good afternoon, everyone. It's always a pleasure to be speaking. Of course, it's a virtual platform, so therefore one is not able to discern as to the connect that one is making through this mode. But I assume that there would be some people that would be interested in listening to me. Now, Sharda has made my task extremely simple because she's covered copiously the ingredients associated with Secretarial Standard 1, and therefore it would not be proper for me to sort of repeat what she has done. What I will do is going to be slightly different from what Sharda did. I'm not going to, reiterate and emphasize on the requirements laid down in Secretarial Standard 2. But what I shall do is that, I will take out certain nuggets, not only from Secretarial Standard 1, but also from 2, and I'll draw upon the legal inferences associated with some of these nuggets and how important it is for us to also ensure that, notwithstanding the law, that for instance, there is I've already received a sort of a question as to the significance of the year in the context of holding meetings of the board, because there's some amount of confusion whether the requirement is to hold 4 meetings in a calendar year or whether it is necessary to hold 4 meetings in a financial year. I'll articulate on this particular point, particularly with reference to the definition of the year, which is not there in the Companies Act, but you have to therefore borrow it from elsewhere. So this is how I shall proceed. I shall look at some aspects which have not been covered by Sharda in Secretarial Standard 1 and offer my views. Of course, needless to say, all the views that I shall be providing are basically my own personal views, and it is not to be assumed that it is compelling on the part of the audience to accept my views, because I have a habit of sometimes I put my foot on the mouth. I have a habit of being a little emotive where it comes to holding my views. So let that not sway you into submission where it comes to acceptance of my views. Okay. Here goes. Unlike Sharda, I'm not very, savvy on the computer. So Rakesh is guiding me, helping me where it comes to, the rolling out the slides. Now, one aspect with Sharda, indeed, she covered where it comes to participation of directors through video conferencing. Now, she's covered what is required, the requirement of a roll call. Then, now, one or two things which I have learned basically through experience of for 4 decades, and of course, learning, unlearning what we learned in the 56 Act and learning what is new in the 2013 Act. Now, of course, the prerogative is of the company to provide the access to meetings for through audio-visual means. But where it comes to preservation of tapes, there is some amount of confusion as to, I've received a question, how long are the tapes to be preserved? The standard says that, the rules say that the standard, the tapes have to be preserved until the audit for the year is over. That means until such time the secretarial auditor has scanned through the tapes for the meetings that have been held through video conferencing, you need to preserve them. Once the audit is over, then of course you can destroy them. And it is a good, in fact, we used to do it in ACC, that it is a good practice for you to make a note in the board minutes, lest there should be some reference later from a director asking for the minutes. We always used to record at a particular meeting the fact that minutes pertaining to meetings held up to this date have been destroyed because of the efflux of time, right? So the second thing is that where it comes to the attendance of the director, of course he has to mention that he is alone and there's nobody else who's there. In case of somebody who's differently able, then you can have an escort. That is permitted. But another way of ensuring authentication of the attendance through virtual means is that it's a good idea to mention the IP location, the IP address from where the director is present. And similarly, where it comes to attendees that are attending the meeting, not necessarily in the capacity of a director, but in the capacity of an attendee for the purposes of specific matters, that also, if they are attending virtually, you could mention the IP address of these people as well. Now, what is this, the case for allowing participation through telephone? Now, the law in India does not recognize the attendance of a director through telephonic conversation, and we have to necessarily ensure that it's done only through audio-visual means. Now, I do not see any wisdom in this, because much as you can record a conversation on which is on videotape, you can also record, you can keep the transcript of a telephonic conversation. And I do not see any reason why the law should stand in the way. In fact, I made a study of what is the position insofar as attendance through telephonic conversation in other geographical jurisdictions in the world. And I discovered that I made a study of 28. In fact, I wrote about this in my book also. I looked at 28 jurisdictions, and excepting for India, all other countries do allow participation through telephonic conversations. Of course, Austria carries it further by saying that you should preserve the tapes for the. So, and in fact, in the UK, the law has, in the Canadian jurisdiction, the law was amended as far back in 1975 to allow participation on the telephone. And in UK also, there is a case law which I referred to in my presentation. And because, the basic reasoning for this is that the validity of a meeting is not dependent upon directors assembling together. You see, a meeting is supposed to be a union of the minds. A meeting is not supposed to be a physical union of persons necessarily, given the fact that today we are doing everything through the virtual mode, including this webinar, right? So there is a strong case for admission of participation through telephonic conversation. Next, please. Next slide, Rakesh. Yeah, some of the fallouts, where it comes to notice, is that you can ensure that you can send today. The law recognizes electronic communication, but when you're sending an email, kindly ensure that you retain copies of the mails for posterity, because emails you may find it very difficult to sort of retrace, particularly if some period of time has elapsed from the date of a meeting. Now, if it is sent through physical mode, the notice, indeed, you should send it to the address of the director as recorded with the company. And there is nothing sacrosanct as to the form of the notice, except for the fact that the notice shall state the date, time, and venue. Of course, now venue is now virtual, given the fact that you are not having meetings physically any longer. I mean, hopefully we shall have a different scenario in the next year. Now, irregular notice. Now, what happens if even there is a question somebody has asked, if by accident you have not sent the notice to a director, it invalidates. This is a Supreme Court decision. It invalidates, because you see, it cannot be if you are having 10 directors and you don't send a notice to the 10th director. It's actually negligence which is unpardonable, and therefore an irregular notice invalidates the business conducted in the meeting. So if a director tomorrow alleges that he has been selectively missed out insofar as the service of the notice is concerned, he can seek reprieve from the court and ask for the cancellation of the resolutions put through. Then, and another aspect is that, the court has also held that suppose you, as a director, do not want to receive the notice. Yeah, I made a note. I don't have to send me the notice. The director has no right to waive the right to receive a notice. And that's a pronouncement in, it's an old decision in Ibrahim said. Next, please. Now, the secretarial standard does not speak about much as Section 96 speaks about the requirement of clear days where it comes to issue of the notice. The standard does not speak about 7 days notice. So therefore, are you to assume that the date of the meeting and the date of the notice is to be excluded from consideration when you determine this period of 7 days? Now, the guidance note actually speaks, it's neither here or nor there. The guidance notes says that you have to eliminate the date of the meeting only. But what about the date of the notice? I mean, you're actually sitting on the fence where the guidance note is concerned by suggesting that you only consider eliminating the date of the meeting. In my view, not only should the date of the meeting be excluded, the date of the notice should also be excluded. And to my mind, although there is nothing provided in the law, it would be a good secretarial practice to assume to follow the pattern of clear days, right? Of course, if you are sending the notice through email, there is no requirement to exclude the date of the notice and the date of because the communication is instantaneous. Next. Significance of the year. Now here, in fact, Sharda made also a point about the independent directors meeting being held once in a calendar year. Now, this is where the MCA has actually gone wrong by amending Schedule 4. Schedule 4 was amended. Schedule 4 is relating to the independent directors. Schedule 4 was inexplicably amended on 5/7/2017 to say that the meeting of the independent directors, one meeting shall be held in a financial year. This is wrong because if you look at the definition of, if you look at Section 173, it speaks about year. The term year is not defined, please understand, year is not defined under the Companies Act. And it is the, the settled principle of law that when a central law does not contain a definition for a particular term, you are always allowed to borrow from allied legislation and in particular the General Clauses Act. The General Clauses Act, year is not defined because it's only the financial year which is defined under Section 240, right? And so you will have to therefore refer to the General Clauses Act, and the General Clauses Act under Section 3, subsection 66 states that the year shall be the year as reckoned according to the British calendar. The British calendar refers to a year as a Gregorian calendar year, and therefore it is appropriate to consider only the calendar year for the purposes of meetings of the board, as also for the meetings of the shareholders. And I, in all humility, let me say that the amendment that has been put through in Schedule 4 is inconsistent with the provisions of the Act. And it is also a settled principle that admittedly a schedule is actually an annexure to the Act. And the reason why you have schedules is to, ensure that there is not much of clutter in the Act, in the Mother Act, as it were. But if there is a competition, if there is if there is an inconsistency between the schedule and the Act, it is always held that the Act shall prevail. And therefore, in all my humility, I submit that the amendment in Schedule 4 is wrong. Next. Agenda. Now, agenda is defined to refer to list of meeting activities. And these, you should respect the agenda, in the sense that you should have the order of events in the meeting should follow the pattern in the provided in the agenda. You should follow a serial order. But what about the requirement of an agenda under the present law? The agenda is also to be issued 7 days prior to the date of the meeting, and not unless, of course, you are having some, you have the authority of the board to provide the agenda for price-sensitive matters ahead of the meeting. So, but in the old Act, there was a decision that no fatality would be rendered to the proceedings of a meeting if the agenda were not sent with the notice, and that's a Bombay High Court decision, which is there. But now you cannot have the luxury of sending the agenda and say the agenda will follow. You are supposed to send it simultaneous with the notice, except for the rider, that where it comes to certain issues where you want to be, discreet and not allow price-sensitive information to go around. You have and for that purpose, the good secretarial practice is to seek the approval of the board in the beginning of the calendar year, to take their authority to circulate items which are price sensitive in nature at a shorter notice, right? And drafting of an agenda, much the same way like drafting of the minutes, it's a fine art. I mean, you need to be no Shakespeare where it comes to drafting. You shouldn't, quote your agenda with flowery language. You simply need to convey what you need to convey as a company secretary. And it should not be like statistics that you leave the vital portions and only give what is not necessary, right? So you must ensure that now the quorum, I mean, where it comes to quorum, Sharda has touched on it, but I want to I want you to understand how the law is emerging. There is this NSE Prime, which is a special listing, which is now being permitted by NSE effective July 1, 2022. Of course, the admission is voluntary. You need to walk an extra mile where it comes to corporate governance insurance. And the quorum, as per the NSE Prime, today there is a different perspective. The quorum is 1/3 of the board, right? But here the NSE Prime speaks about a requirement of a 50% quorum. So tomorrow we can have a specter where the law says that the quorum should be 50%. See, the larger the number of people attending and articulating on a matter, the better is supposed to be of course, there is a saying that too many cooks spoil the broth. But where it comes to quorum, if you have to have an objective decision, you need to have participation of not only 1/3 of the board, but beyond, which is why NSE Prime provides for this requirement. Next. Chairman's role. Now, he's very important. He is the one who's responsible for ensuring, the modicum of procedure in a meeting. And there is always the requirement that you make somebody as a permanent chairman, not because, it's convenient that way, but because, he sets a trend. If somebody else comes in as a chairman, and you have a chairman for every meeting, then that would be somewhat analogous to a bull in a china shop. Particularly if somebody who is not proficient in law I mean, he's going to be like a bull in a china shop where it comes to his role as a chairman. So therefore, the advocacy is for having a permanent chairman. And you should, of course, not make sure that your managing director is never the chairman. Because, he is going to sway the proceedings of the meeting in a manner which is perhaps facilitating the pushing through of certain decisions as the executive head of the company. So please, although in fact it's a sad thing that SEBI has made this requirement of disassociation of the role of the MD and chairman. I mean, now it has become optional. And I am from the old school that believes that the chairman and the managing director's role should be distinct and separate and held by two separate persons. Next. Now, committee. Now, here, this is one, I am opening up a Pandora's box, I know, when I say this. The secretarial standard says that, our guidance note says that the requirements of secretarial standards do not have to be complied with insofar as a meeting of the independent directors is concerned, because the standard does not recognize a meeting of the independent directors to be a meeting of a committee, because the standard says it applies only to meetings that the board and committees constituted. But I do not know why you cannot call an assemblage of independent directors because you see, what is a meeting? A committee. A committee is a subset of the board. Much the same way as an independent directors meeting is a subset of a meeting of the board. So I do not see why you can't call this a meeting of the committee. And besides, it's a legal requirement for the independent directors to meet at least once. And they are not going to be articulating about the Bombay weather or whether the government is going to last. They are going to articulate on important issues. What is the quality of the secretarial, flavor that you get from your documents, secretarial documents? How well are the non-executive directors performing? What is the, how qualitative are the responses of the chairman to points that are raised in a meeting? Whether he is encouraging free expression of thought, etc., and whether he invites dissent. So, for all these reasons, to my mind, in fact, it is important. If not, you draw even if you do not draw up the minutes of the meeting, it is important that the independent directors convey normally you have a lead independent director, and the lead independent director should communicate to the entire board as to what was the outcome of the meeting of the independent directors. In fact, in the company which I retired last, we always used to have the minutes circulated of the independent directors meeting. And where it comes to the NSC Prime document again, the NSC Prime recognizes that the meeting of the independent directors is a meeting of the committee. In fact, the Prime also recognizes that the board shall be informed about the outcome of a decision, outcome of the independent directors meeting, be it in the form of the minutes or in the form of a note which conveys what transpired in the meeting. Now, resolutions by circulation, 175, to my mind, there's a bit of a chink in the law, because it says 2/3 of the board will have to approve. 1/3 of the board have the authority to say that you can, to tell the chairman that kindly have this discussed at a meeting. Now, what happens if you've got the, majority could be, majority, the law speaks about majority. So majority is 50%. Now, if 2/3 have approved, but 1/3 are sitting on the fence, then there is a likelihood that on the 7th day, they might say that we don't agree, in which case you cannot act on the basis of 2/3 approval. So you have to make sure that you have a 3/4 majority before you say that the resolution can be acted upon. And in my view, the proviso that 1/3 can go to the chairman is actually controlling section 175. And the little that I know of law is that the proviso cannot control a section, right? Next. Now, where it comes to minutes, again, do not be like a poet. There is no place for emotions in a meeting, in the minutes, while drawing up the minutes. You cannot write that the chairman expressed his consternation at the performance of the company or the non-performance, or you cannot write that the chairman was exhilarated at the outstanding results. There is no place for any emotions. And then secondly, do not use any convoluted terminology, because it's actually, the minutes are supposed to carry the quintessence of what transpired at a meeting. And what is extremely important, as Shakespeare said, brevity is the soul of the wit. You don't have to give a running commentary on what transpired when a particular item was approved or disapproved by the board. You please give out what transpired, what are the views, and what was the outcome. So brevity is extremely important. Next. Now let me look at some issues on secretarial standards. Now, who has the authority to issue the notice? Only, of course, a person who is authorized by the board has to issue the notice, which is why even if the company secretary issues the notice, it is a good practice to write underneath, issued under the authority of the board. Right? Of course, it's understood that when the company's secretary is issuing, he is authorized by the board, but it may not hurt you if you say that it is issued under the authority of the board. And who are the people to whom the notice has to be sent? The notice has to be sent to every director, directors, auditors, trustees to debenture holders, and by auditors I include the secretarial auditor also, because the secretarial auditor is supposed to be present at the meeting. Now, what about when I'm talking about member, are you to send a notice to the preference shareholder also? In my view, regardless of whether the preference shareholder has got that right of voting because of the failure to pay dividend for 2 years or more, in my view, even if dividend is not in arrears, the notice should go to the preference shareholder also, because the expression used is member, it is not equity shareholder. And there is also a departmental clarification which was issued as far back in 1967, and it says there that the preference shareholders have an implied right to attend meetings under section 172(2) of the old Act. Next, please. Mode of dispatch. It can be dispatched by hand, by post, by courier, or through electronic means, right? Secretarial standard talks about dispatch by ordinary post. To my mind, this is slightly in contradiction of section 20, which provides for issue of a notice through registered speed post and courier service. So to my mind, I don't think we should send notices of meetings, of the general meetings, through ordinary post, right? And explanation is there where it comes to transmission electronically under Rule 18 of the meeting rules. And here, of course, the significance of the clear days is there, in the sense that if you are issuing the notice, 21 days clear notice means that the date of the meeting and the date of the issue of the notice shall be excluded, which makes it 23 days. And of course, if you are sending the notices through physical mode, then you are supposed to add 2 days for transmission, which makes it a necessary requirement to send the notice 25 days ahead of the meeting, if you are sending physical notice. Now, the other thing which comes up is whether this, what is so sacrosanct about 21 days? I mean, is it some astronomical, is it for some, astrological reason that the law mandates for 21 days notice? To my mind, I didn't see the significance of 21 days, except for the fact that that was the pattern in the Companies Act. Now, whether this notice requirement, 21 days notice requirement, is a mandatory requirement, or is it a directional provision? Next. To my mind, there is a certain amount of confusion in the jurisdiction, in the jurisprudence on this point, because 101(1) says it uses the expression may, where it comes to this clear days notice, right? Now, that would suggest the use of may in a legal provision is indicative generally of application of discretion. In other words, you have got some amount of discretion in deciding whether you should do or not do. But equally, in many cases, it has been held that the expression may actually carries the meaning of shall, making it mandatory, particularly where there is going to be some damage, some injury is going to be caused to the law by considering the use of the expression may in a discretionary sense, right? So but where it comes to this 21 days clear notice, I personally feel that it is only a directional provision. Why? Because the law, on the same hand, allows you to hold a meeting at a shorter notice, right? So therefore, it's not as if it's absolutely sacrosanct. And of course, if there's but you should ensure that this is protected. Now, what happens if there's an accidental omission to issue a notice to a member? It does not invalidate the meeting because the Secretarial Standards also reiterates the same position in the law. Now, if there's a delayed receipt of a notice on account of a postal strike or change in the address, that also does not invalidate the holding of a meeting. But however, if there is a deliberate omission which has been made for the purposes of ensuring that some injury is caused to the rights of particularly dissentient shareholders, in that case, if you can prove that I have been omitted deliberately, then I can even go for oppression and mismanagement and also push for invalidation of the meeting. And there is a case law in 139 CAS. Next, please. Nature of the meeting. Now, where it comes to the annual general meeting, the Secretarial Standard provides that the serial number should be provided. That means that you should mention what is the serial number. It may be in the case of ACC, where I did the last meeting was the 84th annual general meeting. Now, some people ask me the question whether you have to give a serial number for an extraordinary general meeting. The answer is obviously no. Because, it's not that you are required under law to hold an extraordinary general meeting. And extraordinary general meeting is something which is happening because something extraordinary needs to be approved by the shareholders. And in fact, if you adopt a pattern of providing a serial number to the extraordinary general meeting, it is, to my mind, reflecting very poorly on the company secretary, because it shows up that he is not been, his alacrity is in doubt, because he should have foreseen that the requirement of taking the approval of the shareholders was necessary. Now, the route map is a requirement. Of course, there is no need for a route map for a wholly owned subsidiary, or only where the directors and relatives are members. And meeting has to commence within business hours. Kindly bear in mind that there is no similar requirement, as Sharda pointed out, for holding a meeting of the board within business hours. Business hours is 9 a.m. to 6 p.m. So you can start your AGM at 5:59 p.m. You can't start at 6:01 p.m. Of course, you can go until midnight. Even if I believe there was one meeting of Hindustan Lever which lasted 7.5 hours. Now, can you shift the venue post the issue of the notice? Now, you can. Sometimes it may be necessary for you to do so because there is some problem with the venue. If you have to change the venue, you cannot do so without informing the shareholders about the change in the venue and the need for the change in the venue, because there's a decision in Sikkim Bank which says that you cannot change the venue post issue of the notice without informing the shareholders. Next. Now, whether the drafts of resolutions for items of ordinary business to be incorporated in the notice is to be given in the notice. The answer is obviously no. But then, where it comes to drafting the minutes, you need to put the approval in a resolution form. You can't say the financial accounts were approved. You will have to put a resolution to it, but where it comes to notice of the meeting, there is no requirement to give out the resolution, the text of the resolution on the body of the notice. Now, all items of special business of course, you need to put the draft of the resolution, and indeed there has to be an explanatory statement, although for some inexplicable reason, 102.2 says statement. The old law was explanatory statement under 173.2. Now, not that the law provides that you can have a very, very cryptic explanation where it comes to the explanatory statement. You need to be equally verbose where it comes to elaborate, where it comes to explaining the rationale for a special business. And for some reason it says that where it comes to disclosure of interest, the directors have to disclose, their directors and KMPs have to disclose their interest, financial or otherwise. I thought every interest has to be pecuniary. It cannot be a sentimental interest, right? So to my mind, I couldn't understand the purpose of the words otherwise in 102.2. And of course, material facts have to be provided as they obtain on the date of the notice, on the date of the meeting. Sorry, it's not date of the meeting. Material facts have to be provided as obtaining on the date of the notice. Rakesh, can you please correct this? It's not date of the meeting, right? Okay, next. 102 is actually a requirement which is mandatory. You cannot hold some material facts, and if there is any abuse of this provision, the resolution becomes defective. There are so many case laws on this point under the old Act also, where if you have not disclosed material facts and on that basis you have taken an approval, the resolution has been held to be defective. Now, one very important aspect which I need to explain is, and this is particularly in the context of what happened when the government announced a lockdown during the pandemic. The first pandemic, the pandemic, if you recall, happened in March of 2020, and that gave rise to a peculiar situation in the law. That is, whether a general meeting which has been convened through issue of a proper notice can be postponed or cancelled, right? Now, the Secretarial standard says that it should not be postponed or cancelled unless it is for some unavoidable reasons. Unavoidable reasons such as rioting or, curfew and things like that. Now, in fact, I faced this problem just after I retired from the company where I was associated. The company issued the notice for the annual general meeting to be held on 7th of April of 2020. Now, why? Because their accounts were adopted by the calendar year, and therefore they used to hold the meeting within 4 months of the close of the financial year, calendar year, right? Now, once they issued the notice on 20th of March, if I recall correctly, 20th of March of 2020, the government of India announced a lockdown, and there was a complete ban on assemblage of people. So the question arose whether this meeting could be postponed. Now, I tried to look at, of course, in an unofficial capacity, though, because I had retired, I tried to look at the law on the subject, and to my horror, I realized that there was a decision in the English court. Of course, there were some decisions in India also. The first of the decisions was in Smith versus Paringa Mines, which is a decision goes back to 1908, where a director issued a notice for the annual general meeting, right? Now, another director issued a notice cancelling the meeting. Now, the matter went to the court, and the court held that the meeting originally convened should take place. And the meeting did take place, and the resolutions passed at the meeting were carried. Now, the reason why the court came to that conclusion was that much as the board has the authority to issue a notice for an annual general meeting, they have the right to cancel or postpone a meeting only if they are equipped with similar authority in the articles. So the Articles of Association should provide for the authority to postpone or cancel a meeting. Now, let's look at the Indian law on the subject. I made a study. Next, here where it comes to COVID, there was a possibility of using this theory, which is called the theory of impossibility of performance. This theory could be used in the COVID era. The theory of impossibility of performance postulates that law cannot force a person to do the impossible. It was impossible for me to go out in the open during the COVID. So therefore, you cannot compel somebody to do what is impossible in a given situation. However, you can use this doctrine to your advantage to even cover areas where there is no impossibility. So the jurisprudence has always advised that there should be a restraint over the exercise of discretion in this matter. So therefore, you should not use this doctrine excessively to your advantage. Now, the Supreme Court held in 4 SCC 57 in the Chandrakant Khere versus Shantaram, they concurred with the decision in Paringa Mines and held that you can postpone a meeting only if the board has the issuing authority has the right to cancel or postpone a meeting. However, there was a contrary view. Of course, this was not in the context of a company, where the mayor, as per the bylaws of the city, the mayor of the town had the right to convene the meeting. So the Supreme Court held that since he had the right to convene the meeting, it could be implied that he had the power to postpone. So the postponement of the meeting was held to be valid in this particular decision. Now, the Kerala High Court has, they have advocated that it's a very pragmatic decision. They have disagreed with Paringa Mines. The Kerala High Court has held that much as the board has the authority to issue a notice, equally it is implied that they have the authority to postpone a meeting. Now, that is an aspect. Well, the Kerala High Court decision has not gone to the Supreme Court, but then advocacy, in my view, would be because of the conflicting views on this. The advocacy would be for us to have an enabling provision in the Articles of Association to allow the board the authority to postpone a meeting in extremely, unavoidable circumstances. And I thought this we should know, given the context of COVID, and these two companies, Ambuja Cement, and I was associated with both, and we had to take an opinion at a very, very high cost to equip ourselves with somebody challenging the cancellation of the meeting. Now, the quorum has to be present throughout the meeting. The secretarial standard, the law does not say, 103 does not have a specific requirement that the quorum should be present through the meeting, but para 3.1 insists. And I think para 3.1 is correct. Because what is the point in having, of course, it's another matter that the validity of a quorum, the sanctity of a quorum today has been lost in the context of e-voting. Listed companies are giving the facility of e-voting. So therefore, the sanctity of the quorum is lost. But where there is no requirement of quorum, e-voting, where there is no facility of e-voting, then I think the sanctity of the quorum does exist. So to my mind, there is a need to revisit the law on this point, whether the quorum should be present, in the context of e-voting being allowed. Para 4.1 says that the auditors and the secretarial auditors have to be present. And in case they are not present, they are supposed to seek leave. They are supposed to, when it comes to the secretarial auditor, the signing auditor need not be there. He can send somebody else to represent the firm if it is a firm. Now, 146 also calls for the attendance of the auditors in general meeting. Next. Now, the chairman takes the chair at the point when the meeting is supposed to be starting. Now, if he is not present within 15 days, 15 minutes, if he is not present within 15 minutes, then the directors can appoint a chair from amongst themselves, failing which the members can elect one from amongst themselves. In fact, there was a meeting of Bank of Rajasthan, which was chaired, which the chairman refused to because there was a huge strife in the management. The chairman refused to chair the meeting. The directors refused to chair the meeting. And one shareholder became the cynosure of all eyes. He was all over the place on television, chairing the proceedings of this meeting. Right. Now, the chair, para 5.2 says that the chairman should explain the objective and implications of resolutions. Now, again, you need to question the requirement of para 5.2 in the context of e-voting. Now, you don't obviously, because e-voting has already ended the day before the meeting. So therefore, where is the logic in for the chairman to explain the objective? And particularly now there is no requirement of a motion being moved. It's only, there's no requirement for somebody to propose a resolution and second a resolution. Next. So obviously there's a need for the standard to be made a little contemporaneous in the context of changes which have happened in the law. Now the requirement paragraph 7.21 says that e-voting is a requirement for, of course, that's also what the rules also say. Where it comes to e-voting, there's a huge important limitation where it comes to removal of auditors and directors, including independent directors. And I'll explain to you, 169 says that you can remove a director, and if you receive a notice, then you are supposed to distribute it to the shareholders and to the director concerned. Sorry. Yeah, if you receive a notice for the removal of a director, then the notice has to go, it has to be received 14 days prior to the meeting, right? By which time the e-voting forms have already gone. And then the director concerned has to be given an opportunity to explain his case. Now, he can take this opportunity in two ways. Either he can give a written submission to the company, which can be attached with the notice, or he has the right to represent himself in the floor of the meeting. And he can explain his piece and embarrass the management if he wants by making because the law speaks about this law is more lenient where it comes to the right of the director. It talks about an opportunity, a reasonable opportunity being given to the director. So therefore, it's not limited to only giving a written submission. So, but then if where it comes to e-voting, how does the director have a right to make a presentation in the meeting? Now, because everybody has voted. So to my mind, the law has to look at the exception in circumstances where there is e-voting and where there is a proposal for the removal of a director. That's why I see a lot of merit in the Quota Committee recommendation, where the Quota Committee recommended that e-voting should end on the midnight of the meeting, right? Of course, you need to explain the procedure for e-voting as per the paragraph 8.53. Next, please. Now, each resolution has to be put to vote separately because the votes are counted separately. And please ensure that director's appointment under 162, it cannot be by, you cannot appoint two directors by one resolution. 162.2 contradicts 162.1. So you have to ensure that there is a separate resolution for each appointment. And the report of the scrutinizer as per 9.5 of para 9.5 has to be submitted within 7 days of the last date of the poll, right? And to my mind, because of the requirement in the Rule 20 says that it has to be submitted within 3 days from the meeting. The LODR provision says that the report of the scrutinizer has to follow within 2 working days of the meeting. So I would prefer a situation, if you are a listed company, please follow LODR and not Rule 21. Ensure that it goes within 2 working days. Next. Now, can you withdraw a resolution which is proposed for approval through e-voting process? The answer is it cannot be withdrawn as rightly specified in Paras 10 because how do you tell your shareholders? But there is one case where there is a precedence of a large company having withdrawn a resolution which was subject to e-voting on the day of the meeting. Now, that is we need to discuss the reasons in a separate forum, but primarily the law does not allow you to withdraw a resolution which is proposed through e-voting. And even resolutions on matters that will cause market turbulence cannot be withdrawn. And of course, no modification should be allowed on a resolution which is put through the e-voting process, para 12. Now, I made a study because we did a study for NSE for a different purpose in the firm. I made a study of about 100 notices of listed companies. And to my horror, I discovered that in 40% of the notices, these were all e-voting companies, and then 40% of the notices carried the byline to pass with or without modification the following resolution. Now, you cannot allow any modification in a resolution which is proposed to be voted. So, empirical evidence suggests that perhaps the fraternity has not appreciated the value of the secretarial standard. So I would reiterate through this forum that it is extremely important for us to comply with the requirements of the standard and ensure that such basic mistakes are not committed. Next. Reading of reports, only the qualified reports of the auditors and the secretarial auditors need to be read. And you cannot, if there is any qualification, you cannot take the reports as read. The qualified portion will have to be read out. I remember a very large made the mistake. There was a qualification, made the mistake of writing that the auditor's report was taken as read, and the registrar of companies carried out an inspection, and the registrar had sent a representative to attend the meeting, and to his horror, were saying what was what is not allowed because the qualification was there, and therefore the resolution had to be read out. There is no provision for giving discount coupons, etc. I mean, there is no bar. Rather, you can suppose you are a wearing apparel company, you can give a 15% discount coupon. That is not analogous to the provision of gifts during the course of a meeting. And there is no ban on the provision of food boxes and beverages. Beverages, by beverages, I mean soft beverages. There is of course, you can't give gifts, etc. Including company products. But there is a very amusing story which I don't have the time to repeat. Next. There is a case for reviewing some of the, as I said, 102.2, one point which I need to reiterate here, that 102.2 includes the appointment and fixing of the remuneration of the statutory auditor as an item of ordinary business. And there is also a provision for ratification of the auditors. Now, of course, this is not required after 7/5/2018. So therefore, the law needs to be revisited where it comes to 102.2, and this item should be deleted, subject to requirements of the company, right? So otherwise, it doesn't make any sense for you to say appointment. Companies are now excluding this, and they are giving a note to say that there is no requirement to appoint because they are appointed for 5 years. Now, declaration of dividend. Now, this is again a contentious issue, which I thought I will flag off here. The question is whether an interim dividend which has been declared and paid by the board should be subject to shareholder approval. It's not board approval, shareholder approval. Now, I submit that 102.2 is defective because it says declaration of any dividend. The term dividend is defined to include interim dividend. So therefore, it follows that even if you declare interim dividend, you're supposed to get the confirmation for the interim dividend from the shareholders. However, it gives rise to one important change in the law which has happened where it comes to interim dividend. Under the old law, there was no specific power which was given to the board to declare an interim dividend. The power was drawn from the Articles of Association, right? And the standard articles also provided the power to the board to declare. But 123 is a specific provision which allows the board to declare and pay the dividend. So some are of the view that there is no need to repeat the process of confirmation at the general meeting. Well, I agree. While I submit that that is the right position in the law, but equally 102.2 needs to be revisited and said declaration of any dividend excluding interim dividend. Okay. So this is all that I had. I don't know how much I have stepped off from my limits of speaking, because I'm my problem is I'm a very garrulous person and I keep talking when I get the opportunity. Thank you.
Thanks, Kalidas. That was a fabulous exercise you did in terms of prepare analysis of the entire provision and also bringing some international perspective to the table. Let me tell you that we just have about 10-15 minutes for questions. And therefore, what I intend to do is there are certain questions which has come to me directly or through our office in HO. And therefore, I intend to take those questions first, so that, there seems to be some practical issues they would like to find some solution through this webinar. One of the directors joined from UK in one company, a director joined from UK through video conference. But due to technical glitch, his video conference could not proceed, but he continued to join through telephonically. Now, he initially joined for video conference. It was going on fine. Then suddenly it stopped and he had to join telephonically. Now, whether he can consider his attending the meeting, as during the whole meeting was present, whether we can pay him sitting fees by recording the above facts in the minutes, whether it attendance to be confirmed and whether sitting fees can be paid. These two
I'll take this question, because I brought up this aspect of telephoning. In my view, the law, you cannot, in fact, one of the courts have said that you cannot take things for granted if they are not provided in the law. Unfortunately, the law now recognizes only attendance through video participation. So if the tapes haven't been tampered, till the time he was present through video conferencing, his presence can be noted. But where it comes to the subsequent part where he was attending only through telephone, I am afraid you cannot take cognizance of his presence. The preferable choice would be to note for the company secretary that there was a video interruption with the result that this person was present only up to item number so and so.
That means we will be entitled to sitting fees as well. Yeah, go ahead, Sharda.
Yes. I mean, I just wanted to add that sitting fees obviously will be entitled. It doesn't say that he has to attend the whole meeting, and it is unfortunate that there was a technical glitch. Which is to be unintentional.
Let's take the next question. In case one director is a foreign director and other two are Indian directors, will it be okay if the notice is sent of the board meeting by email always to all the directors, or is it a hard copy of notice required to be sent? I think a simple email should do. I look at your views on this.
No, unless if any of these directors have specifically requested that we need some hard copy also in some form to be sent. If there is a specific request, otherwise email will do.
Yeah, I think Sharda, most of the companies have gone for board process. I mean, board management
software
where everything is electronic. They don't send anything physical at all. Yeah. I think once a member joins the board, they are told, look, they don't ask for anything electronic, anything physical. Everything will be electronic, and they are very comfortable with it. So they just carry one thing instead of wearing a whole lot of agenda papers with them. Now, next question to both of you: whether roll call is mandatory for board meeting? I think it is.
Yes. Yeah, where if it is through virtual video conferencing, then the roll call is, and otherwise you are anyway able to see each other and speak and
correct.
See their presence.
Okay, now this is a very interesting question. I know there are certain companies where the chairman refused to touch the board minutes. Okay, the reason being that the pandemic has created some kind of a terror in their mind, and they are very scared of touching anything which is coming from outside, unless it is cleansed. Now, is it correct that the company can maintain the minutes in electronic mode, digitally signed instead of taking printouts? Digitally signed, not physically signed. Will that be okay?
I think there is also, in fact, SEBI have also come out with, if I recall correctly, that in the period of the see, what is most important is that it is the the drawing up of the minutes. The signature of the minutes is actually a ceremonious process. But of course, it has to be signed. And the convention, you see, it's not, there is nothing written in the law that the minutes have to be signed in the next meeting. There's nothing. As long as you record the minutes within 30 days, it is all right. But to my mind, in a situation such as the pandemic, where there was no possibility of meeting being held physically, I don't see any reason why the minutes digitally signed should not be accepted.
Sir, I just want to draw the attention. I think guidance note, if you look at page 78, maintenance of minutes in electronic form, I think there are a lot of details given of how it has to be maintained. It has to be retrievable, accessible, further use, all that. I think we have to maintain the sanctity and comply with that, because many times I see some of the company secretaries asking, can we use a digital signature on a printed minutes? That is not called maintenance into the electronic form. So as long as you maintain and comply with this, it is possible to use a digital signature, because there will be a timestamp there.
Yeah. See, but I thought getting the signature signed by the chairman of the subsequent meeting is also a provision under the second standard. And so therefore, the only thing is, if you have not done it earlier, then you will not be able to do it, because the date is going to be of current date, and therefore the problem will exist. But if digital signature is allowed, then they can always do it, right? Okay. Now, this is a very interesting question. Who is having the final authority to decide the date, mode, and time of board meeting? If the independent director asks for some other day, mode, time, then is the company bound to accept it? Anybody wants to take a call on that?
Sharda, how about you?
No. My view is, I think normally the practice followed is the convenience of all the directors is taken into consideration. Correct. That is where the role of a company secretary also comes in. That's why I'm saying it is not just the knowledge that we have, but these interpersonal skills and understanding the dynamics of the people and the situation, and making sure that common convenient time and date is arrived at. It can't be at the decision of only one of the directors.
Yeah, but legality, where it comes to legality, I don't think, well, the independent director, it creates bad blood in the board, all right. But legality, the independent director cannot force you to hold a meeting on a particular date, because after all, the prerogative of deciding on all matters lies with the chairman. But I appreciate the point that you're making, that we need to consider the conveniences of everyone. Now, so if somebody cannot attend, then, well, ultimately, and if there is a timeline to be met, then of course you cannot say, for instance, the accounts have to be adopted by 14 days, 45 days from the close of the quarter, and the director says that I can't be present because I'm outside. You can't, avoid
oblige.
You can't oblige him.
Okay. Then again, it's a typical situation which occurs once in a while. Now they had how can it be practically possible for the company to get the signed minutes of the board meeting on or before the next board meeting? The difficulty, obviously, in this case, he's narrating an example. He says, I had a board meeting on 1st, and I'm also having a board meeting on the 10th. It will not be practical to do it on 10th, the first board meeting, to get it signed. Will that be okay?
Yeah, I'll take this. I'll take this because, you see, as I said, the law says that the proceedings of the meeting have to be reduced into writing within 30 days from the date of the meeting. The law does not say that, in fact, I repeat, it is only a convention. There is nothing wrong if the chairman signs not at a meeting. If he signs it in a private chamber, it is all right, as long as the sanctity of 30 days is maintained. But the reason why we adopt this convention of the chairman signing the minutes in the next meeting is that he says that, look, this is the minutes which have been approved by you, and therefore I'm signing. It's only a convention. It's not the law. So of course, if there are 2 meetings held over a short period of time, there is no requirement that you should adopt the minutes of the previous meeting 14 days in 14 days time. No.
Yeah, Sharda, you have something else to say? Something more to add?
No. It is the same thing. I'm reiterating. I just want to draw the attention of the member who has raised this question to specifically 7.3.5 of the Secretarial Standard. It says minutes of the preceding meeting shall be noted at a meeting of the board held immediately following the date of entry of such minutes in the minute book. So he has time up to 30 days. After an entry is made, then he has to place. So even he can refer to this, he'll get the answer.
Great. Thank you. Now, this is a very interesting case. In case of a meeting where quorum is present, the quorum is fully present, the chairman wants to adjourn the meeting, but majority of the directors desire to continue. In that case, can the chairman exercise his authority for adjourning the meeting?
No, I think we have already stated that in the presentation, that without the consent of the majority of the directors on his own, he cannot adjourn the meeting.
Okay.
If they,
Okay, now this one more question for the day from outside. Okay, if the notice of meeting was given 7 days prior due to unforeseen circumstances, the time of the meeting was changed on the date of the meeting. For intimating the change in time and notice, is it mandatory to give that again that 7-day notice, or is it mandatory to say that with a shorter notice it was there? They gave an original 7-day notice. That's fair enough. But then due to unforeseen circumstances on the day of the meeting had to be adjourned, and the revised notice was given. That was a shorter notice. Does it need to be recorded? It was a shorter notice. That's the question the gentleman is asking.
I don't think so, because see, there are situations where the time has to be changed. You need to explain to the board that you can send a notice communication by email for certain unavoidable reasons. The time has been changed. So it cannot become a shorter notice because the original notice was given in
sufficient days days in advance.
Yes.
So that is okay. Okay. I will do on SS-1 first, and I'll take a few questions on SS-1 before moving to SS-2. What are the types of companies to which second standard on meetings of the board of directors is applicable? Quickly, Kalidas.
Sharda has explained in her presentation.
Yeah, I think she has done it in her presentation. We'll skip it. Okay, is it possible that you people will be able to share the presentation to the members?
Oh yeah, no problem.
Yeah. We'll provide a link not only to all the attendees, those who could not attend, and they'll be able to partake in the presentation which you have given. And incidentally, let me tell you, the total count for the day is upwards of 9,800.
Wow. Now, only one request to Rakesh. There were some typo errors in my presentation.
That will be changed. Yeah, Rakesh will. I'll request Rakesh to make note of it and change it. Okay. Why serving of notice through courier is not allowed? Kalidas first, and then I'll give it to Sharda.
Courier, you see, I think there is a depends on there are some situations where courier service takes the notice in one hand and issues the acknowledgement with the other hand. Particularly when particularly if you are not hiring somebody like Blue Dart, who is costing you the earth. There were some situations where you couldn't, in fact, when courier service was allowed for the annual general meeting, there was a lot of abuse which was being perpetrated by companies with very large shareholding. So, but then, to my mind, if it is, you see, law cannot, unless there is a malafide intention to ensure that the notice is not received, to my mind, to say that, courier service is actually, where it comes to nobody sends it, as you said, nobody sends a notice physically because of the electronic mode. So I think today this question has become your view.
We are having some problem with your. Okay, Sharda, your take on it?
Yeah, because the section itself, 173, does not look at courier, like already pointed out by Kalidas in his presentation. There is a difference between what section 20 says and the specific section relating to notice and delivery of notice says. The Secretarial Standards has just maintained that Sir, I just want to add today, we have gone beyond the traditional courier services to even faster services like Dunzo, Swiggy, and all of them are, they're all delivering documents. And if they are bulky ones, which you may not be able to send by email, you may have to rely on them. But I guess as the law stands, we may not be able to use them and say we have followed, we are in compliance with the law.
Then here, will the consent of a director attend the meeting through electronic board be reckoned for considering any other item not included in the agenda of the meeting? I suppose yes. Yes. Your take on it, please.
Yes, because presence through electronic mode is definitely treated as being present in person, and he can participate as long as he is not an interested director in that. So it can be considered.
Okay. Some questions for you, Kalidas. How much time the proof of sending the notice is required to be preserved by the company? How long?
Well, I would say that, tomorrow, you see, there are these poddars, etc., who are shareholders, who can embarrass the hell out of boards. So since the law is not specific on this, I think that the proof of notice should be kept for at least a period of 8 years, to my mind.
Okay. Sharda, risk management committee is required to be constituted under the SEBI listing regulation. Is SS-1 applicable to meetings of risk management committee? I suppose yes.
Yeah, but it is not in the the 4 recognized committees under the Act, under the Companies Act. So it is voluntary. But I think when it is a listed company, and following secretarial standards for other committees, it may be recommended that they follow it for risk committee, but it is not mandatory.
Yeah, I'll go a step further on this and give my views on voluntary committees. Indeed, risk management committee is a requirement under the LODR. But there are a lot of companies which have voluntary committees. Like in my earlier company, there we had committees for legal management. We had a committee called the ethics committee. Now, I don't see why these are committees which were properly following the requirement of an agenda, minutes, etc., etc. I don't think the law should come in the way of a voluntary, implementation where it comes to voluntary meeting. Because as they say in law, what is not prescribed is not necessarily proscribed. So therefore, if it's a meeting, whether it is mandated or not is another matter. So to my mind, the secretarial standard should be followed for all meetings, regardless of whether the committee is a voluntary requirement or a mandatory requirement.
BN, I just want to add here that you're talking of listed companies, but my experience, I'm also handling a few Section 8 companies. Though it is exempt, Section 8 companies, they are there in not only in education, they are there in health, they're in fintech, in so many areas. They're all voluntarily adopting it in the articles itself, and they are going through the secretarial standard process. So it's a good practice.
To you. How ratification of a majority directors of the company to be taken for decision taken on any other item when the remaining directors were not present in the meeting? What are the consequences if the decision is not ratified by the majority?
Yeah, I think briefly I had covered in the presentation. So at the meeting, if the majority of the directors of the company were not present, then the specific agenda items with the papers and with the decision which was taken at the meeting has to be circulated to those directors who were not present and ask for their ratification. Else the entire minutes, draft minutes, along with a note that this is the specific item which is to be ratified, that has to be circulated to all the directors. And unless it is ratified by all of them, it will not be treated as approved. And my take on this is ratification. Then in this draft minutes, we may make a note specifically that this was an additional item which was there subject to ratification and it has been ratified.
Okay. Kalidas, what is the intent of SSB and including route map and prominent landmarks? I think that's also part of the rules, I suppose.
No, the route map, in fact, you see, now of course with Google Maps being there, which points to a particular location, this requirement has become actually redundant. But then, the advantage is that, the shareholder is in a position to come to the meeting if he has got a map. So, he's not in Borivali instead of being in Mulund. So that way it is it's intended to be advantageous too. I remember when I was company secretary in the company, we held our board meeting, annual general meeting in the registered office, where the only train which would stop, the long distance train would stop for 30 seconds. And one shareholder came all the way for this meeting, and I said it's over after half an hour. But then there was no malafide. But here again, let's consider the requirement from the standpoint of the shareholder. It is intended to enable him to attend the meeting. So that way, what is the problem if I attach the Google map again?
Interestingly, I also recall how you landed up in Nariman Point instead of coming to BK's.
Yeah, that's another story.
That's internal. Okay, Sharda, this for you. What are the consequences if independent director is absent from the board meeting called at shorter notice?
Yeah, at least one of the independent directors should ratify this decision.
Okay.
Yes.
Kalidas, can a member physically attend the AGM after he had voted through remote e-voting? What happens if he again votes at the meeting?
Yeah,
It's not possible. He cannot vote at the meeting.
Yeah, he cannot vote.
The service provider automatically.
He can always attend the meeting physically. There is no problem.
Yeah,
but his vote will not be counted.
But there are certain questions which are raised by members. Now, they say, look, they want to hold a meeting in physical form. Will that be allowed?
Well, you see, now I think because the MCA has issued a notice, I think it would be risky for a company to hold a meeting in physical form, because some shareholder may say, I didn't get an opportunity to attend through electronic means. So I think as long as the MCA circular is valid till 31st of December, it's too much of a risk for a company to hold a meeting in physical form.
Okay. When a director joins the Sharda, for you, when a director joins the meeting by video conferencing, is it sufficient to say that foreign director was not absent under section 1(1)(b), even if he does not physically attend the single board meeting in a period of 12 months?
Yes, because attending whether through physical or virtual mode through video conferencing is counted for the purpose of quorum. And so he will not get disqualified merely by participating through an electronic mode.
Yeah, I just wanted to add one more point here. The 167 is the disqualification in this law is much more stringent than 283(1)(g). 283(1)(g) provided for disqualification where a director was absent from 3 consecutive meetings without seeking leave of absence.
Correct.
Right? So leave of absence, if you could seek, you could indefinitely put off your disqualification at 283(1)(g). On the other hand, here, even if you take leave of absence, if you're absent for 12, all the meetings in the calendar in 12 months, then you are disqualified, whether you have taken leave or not.
Okay. Sharda, this for you. Can the chairman reject remarks, comments received from directors on draft minutes after 7 days of circulation of the draft minutes?
I think what the standard says is if the chairman is authorized by the board, then he can choose not to consider the comments. But honestly speaking, practically, I think even if it is beyond 7 days, yes, people do get the time as long as the chairman is able to finalize the minutes within the 30 days.
Kalidas, a public limited company having 800 members convened a general meeting upon due notice. However, only one member was personally present at the meeting representing 5 bodies corporate. Is this a valid quorum?
Yeah, you see, representation under 112 does not give rise to the presence of a member through proxy. So if I'm representing 5 companies, I'm actually 5 members, because a company cannot be present physically. So the same representative can be representative for 5. and as long as there's one member physically present, then there are 6 present, including this person who's representing 5 companies. So therefore, the quorum will be ensured.
Okay, let me twist this question. Let me twist this question a bit.
Yeah.
As an individual, I have got about 5 folios. I am attending through 5 different instruments. Will I be considered as 1 shareholder or 5 shareholder for the purpose of quorum?
In my view, in that case, if you're a individual shareholder,
5 different instruments. I'm joining through 5 different instruments. I may be one of the joint holder in each of these 5 folios, or maybe the first holder in all these 5 folios, having different joint holders. Okay.
I think here the answer would be a little different, because I'm a person, whereas I'm as a representative of a company, I'm actually representing 5 different mandates from such. In here, I will not be considered as 5 members, to my mind.
You have a different take, Sharda, on this?
No, I think I agree with sir.
Okay. Sharda, for you, what is there if an additional agenda and item of dispatch of agenda notes to the directors? How should the company deal with such additional items?
I think I have covered in my
You covered, I saw it, you covered it. Okay, fine. While circulating draft minutes via speed post, additional days are not to be added in 15 days.
Yeah, because it is just about delivering it within, 15 days.
Notice time. Okay.
It does not, yes.
Now, a very interesting question, which may not happen all the companies, but certain companies have this practice. Why is it the company secretary should be seated with the chairman of the general meeting? And it says at right side of the chairman.
Well, this is in fact actually the company secretary is, to my mind, to end this discussion on a lighter note, the company secretary, I had a very senior person in my formative years. I congratulated him on the AGM. He said that, look, the company secretary is like a sports master school. I said, sir, what is this analogy? He said that it is when the sports is there, the sports master gets all the accolades. He gets all the attention from the school authorities. Similarly, where it comes to an AGM, the company secretary is supposed to be the one who is supervising everything. So let him have a share of the limelight. So I think, and in fact, the 4 or 7 annual general meetings I did in one company, and there are 7 pats I got from a gentleman who's no longer an icon, but 7 pats I remember distinctly in my life as a company secretary came at the time of the annual general meeting. And I think it's important for the company secretary to have his, presence felt. And today, remember that we are acknowledged as part of the senior management, even no less than by SEBI. So therefore, to my mind, there is nothing wrong in the company secretary being seated next to the, but there are some companies which respect hierarchy and relegate him to a back seat, which is unfortunate.
Sir, I just want to add, not under the law, but I think we may call ourselves anything, but our conduct, the way we conduct ourselves, I think that should speak for who we are and whether we are valued by the management, and the respect we get, we should earn that respect.
Exactly.
The law may give a recognition, not give a recognition, but it also depends on how we conduct ourselves.
Sharda, I would like to quote Mr. Deepak Parekh on this. From what you say about earning respect, Deepak Parekh has gone on record as saying that I do not like that company secretary who toes the line of the management. He wants the company secretary to give perspective different from what the management thinks. So which means that he considers the company secretary as highly valued.
Okay. Well, friends, that brings us to the end of today's program. We also have a program on SS-3 and SS-4 on 27th, followed by one more on 29th, which was what was scheduled on 26th is now postponed for reasons why the concerned panelists as well as are slightly busy with some other activity. So that intimation will be sent soon. I will now hand over the proceedings to Mr. Rakesh for doing the balance formalities. Over to you, Rakesh. Saurav?
BN, before he comes in, I just want to place on record and acknowledge the support that we have got from the Secretariat, Rakesh, Saurabh Jain, and I don't know who else is there in the back end. Of them, and also my team. I want to call out my young team, Kritika Murli, who was the one who prepared all the presentation. Then I had got a lot of important inputs from Srinivasan and Rajeshwari, who are young budding company secretaries. So it has been a team effort, and I would like to thank all of them.
I would like to thank Rakesh in particular, and of course I have no team excepting myself, which is why those errors crept into my presentations. He correctly pointed out, and he is a fantastic resource where the institute is concerned.
Okay, anyway, I was wondering about the Shahid Ki Beti certificate, but that formalities will be completed later. Thank you very much for your presence, both Kalidas as well as Sharda, taking your time out, and I'm very happy to see Sharda back in action. She was not available for a long period of time. Rakesh is there. Rakesh, will you take over from me at this point in time?
Yes, sir. We request you to offer vote of thanks, as there is no Shahid Ki Beti certificate. The members are from expert group only.
Oh, okay. From the committee itself. Okay. Thank you very much again. I have no words to say anything further than this. And it was wonderful to have you both on board. And you both have been contributing a hell of a lot as far as the second standard expert group is concerned. And I wish I will also have you again on board the next term when the council is getting constituted. Thank you very much again. And thank you, friends. Thanks for your attendance. And the number, I believe, has crossed 10,000. Thank you.
Bye-bye.
Thank you for the score also.
Thank you.
Good day. Good evening.
Bye-bye.
Bye-bye.